All rise. Good morning, sir. Good morning, all present here and the one viewing the proceeding online. It is my privilege to introduce you to the Honorable Justice, Mr. H.T. Narendra Prasad, born on 1st June 1966. Justice Narendra Prasad has a rich education background. Sir has completed his BSc from DVS College, Shimoga in 1990, followed by his BBA from Vidyavardhaka College of Mysore in 1993. Sir began his career in enrolling in an advocate in the High Court of Karnataka in 1993 and started practicing under the guidance of renowned Professor Ravi Varma Kumar. Over the years, Sir gained experience in various legal domains, including constitutional law, service law, administration law, public law, property law, environmental law, arbitration, and more. Before the High Court of Karnataka, Karnataka State Administrative Tribunal, and Central Administrative Tribunal. Sir's service has stayed for further demonstration, where he was appointed as a High Court government leader in 2006, a position Sir held until 2013. He continued his remarkable contribution as an additional government advocate until he elevated to the bench in 2018. On 2nd June 2018, Sir appointed as an additional judge to High Court of Karnataka, and on 26 February 2020, he was appointed as the permanent judge. Justice Narendra Prasad, remarkable unwavering contribution to the justice have made him a highly reputed figure in legal community. We are indeed fortunate to have Sir as a part of our 5th National Moot Court competition at St. Joseph's College of Law. Thank you, sir.
Good morning, sir. Mr. L.P. Raghu is a prominent personality in the field of litigation. His contribution to the field includes 48 years of experience, has sure helped bringing the standards of legal practice in Bangalore to newer heights. Holding an LLB degree and a gold medal for highest marks in constitutional law from Bangalore University, Mr. Raghu possesses a strong academic foundation that complements their practical experience. His academic achievements reflect a commitment to continuous learning and intellectual growth, qualities that resonate well with the aspiration of young legal minds of participating in the National Moot Court competition. The Moot Court Society of St. Joseph's College of Law is grateful to have Mr. Raghu as the judge in this event. Thank you so much for your valuable presence, sir. Thank you.
Good morning. It is my pleasure to introduce the judge for the final rounds today, Advocate Santosh S. Nagrale. With over 25 years of experience, Mr. Nagrale is a highly respected legal professional. He holds a BSc and LLM degree from Karnataka University Dharwad and an LLM degree from Toronto University. He began his career in 1999 and has since built a diverse practice covering criminal, civil, service, property, and educational laws. He has appeared before various high courts and tribunals across the country and has worked with eminent legal minds, including Senior Counsel Shri K.N. Nagraj, now the Additional Solicitor General of India. He also serves as a panel advocate for the Honorable Governor of Karnataka. Currently, he is the Special Public Prosecutor for the Anti-Corruption Bureau, Karnataka, handling several key trials, many of which have led to convictions. He is empaneled with numerous esteemed institutions such as Canara Bank, Indian Oil Corporation, and leading universities. Beyond the courtroom, Advocate Nagarale has imparted knowledge as a part-time faculty in KLE Law College and Sheshadripuram Law College, inspiring budding legal minds for over a decade. We are truly honored to have him with us today. Welcome, sir.
Greetings, all. The National Moot competition is now in session. With the Honorable Judges, Justice H.C. Narendra Prasad Gowda, N.P. Rego, Santosh Nagarale. If it's convenient, Your Excellencies, may we begin with the hearing of the matter? First, we'll have the petitioners, followed by the respondents to argue before this honorable bench. 35 minutes will be provided for each team, which will include rebuttal and sub-rebuttal. The parties present here are the petitioners, Team 8, and the respondents, Team 7. The case before the court today is exploitation of workers in IT sector versus the state of Kandana and A&C Private Limited. If the honorable bench please, the proceedings may be.
The council takes permission to approach the dais. The council seeks permission to address the honorable bench collectively as your lordships. The council is present here on behalf of the petitioners in the case of injury exploitation of IT employees. The council seeks permission to proceed with the statement of facts. So, the Republic of Indica has witnessed a remarkable growth in the IT sector in the recent years, and state of Kandana is the home of a tech capital, Bangalore, and Bangalore is the hub for all the MNCs and IT industries in the country, and under which A&Z Private Limited is a company that delivers innovative software solutions. Rachel is an employee under the A&Z Private Limited company, and she is a tech worker. She is a developer of a software, and she is responsible for creating, testing, and launching of the complex software solutions for the international clients. And in November 2024, the state of Kandana amended the Kandana Shops and Establishments Act and passed an enactment called Kandana Shops and Commercial Establishments Amendment Act 2024 that legalized the 14-hour work day for employees working in IT and business processing industries. Now, even before the passing of such an act, Rachel was made to work beyond her working hours, that is reasonable 9 hours. She was made to overtime regularly, but after the after the enforcement of this act in November 2024, Rachel was made to work beyond 15 hours a day, and which on certain days it extended up to 17 hours, and often those extended hours were uncompensated. Now, after the enactment of the act in December, Rachel was diagnosed with had symptoms of severe depression, spondylosis, chronic neck pain, and vitamin deficiency. When she consulted a doctor, she was diagnosed with work-related stress disorder, which led to insomnia, anxiety, and she was advised that if she does not take a minimum rest of up to 6 to 7 hours, that she would be prone to ischemic heart disease. And but later, after diagnosed with all such medical conditions, she has written emails to her HR stating that she requires leave and reduction in her working hours so that she could seek some medical help for the conditions that she is suffering from. But the emails went unheard, and the HR denied that, stating that the needs of the company are more, the demand is more, hence it is difficult for him to grant the leave. On December 25th, 2024, she came to the office, and because she had to attend an international client meeting, therefore she was made to sit for 4 long hours in a meeting, after which when she went for a lunch break, she collapsed, and she was taken to the hospital and declared dead before she reached the hospital. Hence, the postmortem report of Rachel clearly stated that the postmortem report clearly stated that the death was the cause because of a heart disease, that is heart attack, which was nothing but due to the stress and all the diagnoses that she had before. Therefore, NICS, Nascent Information Technology Employees Senate, has filed a writ petition before the High Court of Kandana challenging the constitutional validity of the amendment. This writ sparked a nationwide importance, and hence the Supreme Court has taken this in-ray exploitation of workers in IT sector case. The council would seek permission to proceed with the statement of jurisdiction. Now, the Supreme Court of Republic of Indica has been granted original jurisdiction under Article 32 and 142 of the Constitution of Republic of Indica. The suo motu jurisdiction basically refers to the court's authority to take up a case on its own, even when a petition is not being filed by an aggrieved or a group of individuals in favor of the aggrieved party. Now, the jurisdictional foundation for the Supreme Court's exercise of suo motu is under Article 32 that clearly states that when an individual or any group of persons have been violated by their right, their fundamental rights have been violated, they may proceed to the Supreme Court to seek for enforcement of such rights. And according to Article 142, the Supreme Court has the power to take up any matter before it in order to do complete justice for the matter pending. And also in Order 38, Section 12, Subsection 1, Clause A of the Supreme Court Rules 2014, the Supreme Court rules clearly states that a public interest litigation may also commence as a suo motu petition. The Council seeks permission to move forward with the arguments of... No, sir. It's basically only when there is a violation of fundamental rights or an individual or a group of persons can approach the Supreme Court for enforcement of such violations. Yes, they can. So the first issue will be dealt by me, that whether the issue one is whether an act violates Articles 14 and 21 of the Constitution by legalizing excessive work hours that endanger the health and well-being of the employee. The counsel for the petitioners would humbly like to submit before this bench that the amendment passed by the Kandana state is clearly in violation of Article 14 and 21 of the Indian Constitution, and it is essential that such fundamental rights are not to be violated, and it is the duty of the state to keep in mind while framing the legislative policies or enactments that such fundamental rights shall not be violated. It is moving to my sub-arguments, the Act is clearly in violation of Article 14 of the Constitution of Indica. Article 14 clearly states that no person should be, all persons are equal before law. On the ground that there is no rational nexus or intelligible differentia under Article 14 for discriminating just the IT sector employees compared to any other sector in the state. So, the normative anchor for our... Yes, the legislative power is there, but it is essential that the legislative power used does not completely violate the Article 14. It has to be reasonable. There has to be a reasonable... And 21. Firstly, Article 14 and 21 have been violated. Secondly, it is also in violation with the international conventions and the DPSPs to which the Republic of Indica has been a signatory to from the very beginning.
According to you, that Article 14 has been violated.
Yes.
How can you establish that?
Yes. Basically, the normative anchor for Article 14 lies in the presumption that all people are fundamentally equal. But however, in the recent or judicial precedents over the time, we've come to see that the court has given the power to a state to make legislations that have to satisfy two grounds. One being intelligible differentia, the other being the rational nexus. According to Blacklaw's dictionary, arbitrariness is considered to not be supported by any fair, solid, or substantial causes. I would like to state that the amendment made by the Act is not fair. It's not based on solid grounds, and there is no substantial causes. And in the case of Raj,
How will it affect the
under Article 14 because the economy of the state of Karnataka does not completely depend on the IT sectors and BPM sectors. It definitely depends on every other sector that is a part of the state. So imposing such excessive working conditions only for IT sectors is a clear violation of Article 14. In the case of Rajbala versus State of IT sector and business processing industries.
Establishment Act. There is Public Act. 25. We only reset there.
The whole act, the amendment is applicable only to the IT sector and BPM sectors.
Yes. Is it made applicable only to the IT sector?
Yes, sir.
Where is that?
It is there in the amended Kandana Shops and Commercial Establishment Amendment Act of 2024. IT industries and BPM industries. Now, in the case of Rajwala versus State of Haryana, the court held that the rationality and reasonableness must be the characteristics for the classification to be made under Article 14. So it is essential that there is a rational nexus and intelligible differentia in order for a state to make a differentiation between the similar class of people. As noted in the case of Shaira Banu, a classification can be considered to be intelligible only if it passes the test for anti-discrimination under Article 14 of the Constitution. That is, the state can only make logical and reasonable differentiation, not discrimination. Discrimination is arbitrary in nature, whereas the Constitution itself provides for class. Yes. It should not be for the IT industries because it has to be like the others for the IT industry, that is 9 hours per day, not beyond that. And it is concluding, there is no reasonable classification because the IT sector is treated, IT and BPM sectors are treated and discriminated in a way, stating that as though they are the only ones contributing to the economy of the state of Kandana and not any other sectors. Now, coming to the rational nexus, it is clearly stated in the Act that the object for passing such a amendment is that is for the growth of the economy of the state of Kandana and to meet the global competitiveness and international demands. Now, the state has clearly failed to establish a rational nexus between the object stated and the classification and the discrimination that is being made for the IT industries only. Because in the object, they are stating that the economy of the state should be increasing, and definitely the economy of the state entirely does not depend on the IT and BPM sectors. Therefore, it clearly lacks rational nexus. And in one of the cases, it is held that the court has to always consider the objective of the classification, and there must be a reasonable correlation between the object stated in the Act and the discrimination that is being made, and the state clearly lacks it in this case, in the present case. Now, moving to my second sub-argument, that it is clearly violative of Article 21, I would like to bring to the notice of the court that it is stated in various judicial precedents that right to life is the most significant and essential right that is available to the citizens and non-citizens from outside the country. Article 21 guarantees right to life and personal liberty for every individual in the country. The court has asserted in the case of Unni Krishnan versus State of Andhra Pradesh that Article 21 is the heart of fundamental rights, having enough positive content, though it is worded in negative terms. Now, in Chameli Singh versus State of UP, right to live, guaranteed in any civilized society, implies right to food, water, decent environment, education, medical care, and shelter. Firstly, I would like to say that this act is clearly in violation of right to human dignity. Every human being is he's a social animal. He needs to mingle with people. Just confining him to going to work for 14 hours straight, he will he shall not have sufficient time to do any other interest that he wants to build. So that is clearly a violation of human dignity. And the state fails to ensure a decent environment because it is imposing excessive working hours on IT industries, which will in turn lead the employers.
Is there any material to show that death of that employee because of this increase in that?
Once.
Suppose that she has died because of heart attack.
Yes, but in the in para 1.5 of the proposition, it is clearly stated that she was November 2024, December 25th, 1 month, 1.5 months.
Can we say that because of that work she died?
But sir, I would like to bring to the notice of the bench that she was made to work beyond her working hours even before the enactment of this act, which was already exploiting the workers.
Attention that it may affect, but your road is on the basis of the death of that employee. Is it that because it is hardly some days she has not worked? It may affect in the future, that could be that right argument. But because of this death, this is the reason for that amendment is bad. This is that.
Sir, even before the amendment, Rachel was made to work for about 12 to 15 hours in a day, which is beyond the statutory limit established by the state of Kandana. So hence the employer... 9 hours is a reasonable time, but on everyday basis, if she was made to work beyond 12 hours, beyond 15 hours, that is humanly impossible for a person to do that.
But only after that amendment, what is that? 3 hours fixing itself is a violation, it's different. It is not below that.
Yes, sir.
We have to decide on that amendment. By amendment, what are the rights which are being violated?
So clearly,
Yes, 21, Article 21, you taken that teacher case, but still that cannot be established because she has hardly worked for some months.
but the enactment was made in November 2024, but the state has clearly failed to regulate the employee sector way before such an amendment that is being made. Because clearly Rachel was made to work 15 hours way before this amendment has come into force. So that is what has led to this. And now when the state is legalizing such thing, it is only going to lead the employer to exploit her even more, which is going to be completely unreasonable. She will not have time for anything else to bring up her interests or to just give family time or to have a work-life balance. It is very essential for us human beings to have a work-life balance. That is, we have to prioritize our personal life as well as professional life. We cannot merge it together. And in her case, it was mostly professional life. She barely had a personal life. And under Article 21, it is also a violation of right to health and medical aid. In the case of Vincent versus Union of India, the court stated that the right to life under Article 21 also includes right to medical attention and a life free from diseases. Now, when the state only is bringing an amendment for extension up to 14 hours, it is obviously proven that she is going to be prone to more diseases. That means it is clearly violating of Article 21 as that she is not being able to live without any diseases. She is prone to all kinds of diseases because she is made to work for those kind of excessive hours. Now, in the case of Sina B versus State of Kerala, the Kerala High Court has defined burnout as a phenomena that poses danger to physical and mental health of those who do overtime regularly in medical as well as any other profession. So clearly, as stated here, this is a case of burnout. She is facing medical issues, she's facing mental illness, she's facing physical illness. This is a clear case of burnout and hence depriving her from right to health, to live without free from diseases. And I would also like to state that this amendment made is not under the exception under Article 21 that states that no person shall be deprived from his right to life and liberty other than any procedure established by law. I would like to state that this is not a procedure established by law. Even though the courts say that in order for a procedure established by law, it should have a proper legislative backing. The Act has the proper legislative backing, but it has not considered the vital inputs of the employees working in the IT sector. That is an essential condition that the court has to consider.
Before enactment, the draft legislation has been published, and that any association has made an objection.
So we are not aware of such facts. Sir? International convention, sir. Yes, it is clearly violative of this labor law itself. Before the amendment, it was 9 hours. She was made to work. Huh? I'm sorry. This labor law is not violated, but we are questioning the validity of this amendment. Because the amendment is clearly violative of Article 14. Now, violation of international conventions, the Universal Declaration of Human Rights. In Article 25 of the Declaration of Human Rights and even various articles in ILO Conventions 1919 that talks about working hour regulation, it is clearly stated that no person should be made to work beyond 48 hours in a week and 9 or 8 hours in a day. This is clearly in violation of all the international conventions. My co-counsel will further elaborate on this issue. Sir, Article 51C clearly. It has been ratified by Antica. But the ILO Convention of 1919 regulating hours of work for employees, Indica is a signatory of that, and Indica is also a signatory of Universal Declaration of Human Rights that clearly establishes that a human being needs proper decent environment for living, including work, living, office, or at home. Sir, according to Article 51C, it is the duty of the state to make sure and keep in mind and foster to the international treaties and conventions that is signed by the Republic of Indica. Now, it is of persuasive value itself. Yes. But however, when it is clubbed with the fundamental right, that is Article 21, it is clearly enforceable, sir.
There is far to exempt the IT sector from the operation of SAC, isn't it?
Sir?
There is provision in the amendment to seek exemption from the operation of the SAC. Are you aware of that?
The amendment clearly states that it is applicable only to these sections that are being amended are applicable only to the IT and BPM industries.
Part is in section 20, as the state government exempt IT, BPM establishments to 7.1 and 12 they comply with sections 7.1A and 11A. Have we taken note of that provision in the amending act?
Sir, it is clearly exempting here, sir, because the amendment of section 7, inclusion of subsection 1, states that no employee in any establishment except IT and business processing industry shall be required or allowed to work for more than 9 hours on any day and 48 hours given.
So it has the power to exempt been decided by the office. Have you asked for exemption at any time?
It is, but sir, isn't it implying here that if it is already being exempted from section 1A because they are clearly made to work 14 hours. But hasn't the state already exercised that power because it clearly has exempted the information technology?
The amendment as it passed here before us, it includes the power to exempt, has been decided by law, saying that it is a prerogative of your working conditions, already you are complying with Article Section 7.
You are representing and your privilege is only against the IT sector. You are not representing your privilege is by the other sector. Because IT sector, there is an exemption for, provision is there for exemption for IT sector. But there is no such provision for others. They have been actually having more privilege than
There is a power for the state to exempt IT and BPM sectors, but the exemption, the power used is clearly arbitrary because it is unreasonable to impose 14 hours of excessive working hours on IT employees or any employee for that matter.
that's why the state saying that you can't do it for a district IT. They could have, because the power has been written by the state.
But sir, even if the power is given to the state, it is essential for the state to keep in mind the fundamental rights, Article 21, when it is clearly imposing 14 working hours on IT industries and BPM industries. It is depriving people, employees of the IT industries from right to human dignity, right to life, right to medical aid, right to livelihood in fact.
No, see, they are examining only in the aspects of the party which is before the court. It is only IT industry which is before the court. It is not that hardware industry is before the court. It is hardly affected because you have no more options to that there is an exemption. When legislator has started, because the work in the IT industries, it may be very hard that if you work more than 9 hours, they make order, they put that class, they can examine. But it is more effective than others. They are not before the court. They have no privilege at all.
So that is the point that even when the legislature only has granted power to the state to exempt IT and BPM industries from in certain circumstances, then even though such an exempt is being exercised by the state, it has to be reasonable. It cannot be a clear violation of human rights.
Section, now that the shopper, the Establishment Act, Section 20, the board to exempt the establishment. You have this book?
No, sir.
Where the state government is satisfied that he rules applicable to the employees in any establishment provided benefit, which in its opinion are not less favorable than those for which is chapter X provision, it may by notification exempt the establishment from all the provisions of this chapter subject to such condition as may be specified in the notification. In the main act itself, they power for exempt each thing. The party who is before the court is addressing remains only in respect of the IT, that he can seek for an exemption.
But it is already,
You want the entire legislation as
we want only the Amendment Act to be declared violated because it is clearly discriminatory. It has inclusion of Section 7, subsection 1 and 1A that is clearly applicable only for the IT and BPM industries.
Yes, see that legislator has thought that it may not be possible to work continuously for 15 hours. Especially, I think they have concentrated more on IT industry. They have given that exemption that there is a break for every hour. And they have balanced,
For every 5 hours,
see, they have balanced human rights, employees' right, and also balanced the economy of this country. Even the transport special provision has been made, all securities, all care has been taken.
but sir, this was already there in the Act. In the previous Act also, it mandated a break after 5 hours. They are not, here they are reiterating that. And even before this, for women, there was provisions for them to, if they are working beyond 8 p.m., it was the duty of the employer to provide for transportation facilities. Now they are just extending it to everyone. But clearly, just by providing transportation facilities or just by providing breaks, it cannot be held as not violative of Article 21. The person is still made to sit at work for 14 hours, even if he has a break. again, under right to human dignity, it is clear that humans are social beings. They need to not only confine themselves to one place. By imposing 14 excessive hours, you're confining that person to just one place, to the working place. And when you confine that person to one place, he has no time left for any other interest that he wants to pursue. And this is a given that 14 hours is the bare minimum. The employer can also ask the employee to extend beyond 14 hours. And given that, if it extends up to 16 or 17 hours,
That is not concerned. If it is also beyond 14 hours, he can't do it because there is no power. Here he can't, he has a power because there is a legislation. You can ask, employer asks you to work for 14 hours. But after 14 hours, he has no right. Anything is happened, then you have an right to take an action against that. Then also, is
No, if you have, if you have fulfilled this 9-hour issue over there, then you can seek exemption also provided for PC section 70. We work up to 14 hours daily and 72 hours weekly, subject to mandatory 1 hour test. But if you see no employee in the establishment so shall be required to be allowed to work for more than 9 hours on any day and 48 hours in any week.
no, so they say,
There may be some contradiction over here, but if you really see there's the standing issue here, the bar and restrictions of 9 hours. Please read the first part. In section 7 of the Principal Act, substitute subsection 1 with no employee in any establishment except information technology, business process, management establishments shall be required allowed to work for more than 9 hours on any day and 48 hours in a week.
yes, that is for any industries.
Employees in information technology and business process management establishments may work. It's not a mandatory requirement there. Up to 14 hours daily and 72 hours weekly. Subject to mandatory 1 hour rest intervals after 5 hours of work. Overtime wages at twice the normal rate under section 8 for hours exceeding 9 daily or week 48 weekly. Weekly compensatory less for 24 hours, consecutive hours. So there are provisions here that will mitigate on any difficulties that an employee could suffer by working there. It is me, it is not a mandatory requirement. Shall is not used in the section.
So the state has used may, but given that the state only is giving the power to the employer to take the maximum, to exploit the employee to the maximum extent, no employer would deny.
So if the employer were to do it, the state would always be addressed by the employee.
That is exactly what is happening here. The employee is dead. The deceased, and based on that,
But that's only an exception issue, and we are the active force in the cinema. She has fallen ill and she has passed away. You can't address issues before that. So she was working in normal conditions before that.
she was clearly,
So if she had developed any illness or any defect in her setup, in the physical setup, it could not be blamed entirely on this enactment. This cannot be used as this is only they say a single swallow doesn't create someone.
but studies have clearly shown that when people are made to work for excessive hours, they are definitely prone to mental illness and
What did we produce to confirm that? Before
I have a report
is
stated.
that in your page now, in your petition?
Yes, sir. Page number. Page 30. para 57, WHO's report published in 2022 showed that 1 billion of people living with mental disorder lived in 2019, and out of which 15% were working age adults experienced mental disorder. Work amplifies wider societal issues that negatively affect mental health, including discrimination and inequality. So basically, the health of the employee is not considered, given that excessive working hours is imposed. Even if the word may is used by the state, the employer would not hesitate even a little to take the maximum benefit out of an employee. So he would obviously mandate the employee to work for 14 hours in a day, which is a lot for an individual, because he will have a normal human being will require minimum rest hour from at least 6 to 7 hours on a regular basis, and this.
The board is published in June 2022. Obviously, we not have taken into consideration the developments so far as this national distance, and it doesn't really say it's just giving the mental disorder. There is nothing very expansive here to enable us to arrive at a decision that it is exploitative. You have only a single case here to substantiate what you say, and you are relying on a WHO report which is not really based in entirety before the bench.
Sir, but it is clearly, logically.
No, is it part of the exterior?
No, sir.
You only make a reference to it in paragraph 37.
Yes.
You not come out the right position.
Apologies, Your Lordship.
No need to apologize. It's not there, it's not there.
But given that excessive hours are imposed, even if it's a 2022 report, it is clearly showing that when a person is made to work for excessive hours, it is a person, any individual working in any sector or any industry, he is definitely prone to certain mental illness, because sitting in front of a computer would definitely have a wide impact on our eyes, will likely have an impact on our mental health, and it is very essential for the state to consider all this before making such an enactment. Even though the word may is used, the employer would not think for a second that to give less working hours to an employee. He will obviously make the most of what is mandated by the state. And moving ahead, it is violative of violation of right to disconnect. Violation of right to disconnect is not recognized under the Constitution of Indica. However, in the state of CESC Limited versus Subhash Chandra Bose, the Supreme Court observed that health is a state of complete physical, mental, and social well-being, and not merely the absence of disease or infirmity. Now, keeping this in mind, if the bench would recognize the right to disconnect under the ambit of Article 21, it will act as an imposition of a reasonable check on the employer's extent of exploitation of the employees. This would, therefore, I would like to humbly submit before the honorable bench to recognize the right to disconnect under the ambit of Article 21. It is clearly like it is recognized under UDHR for the betterment of the employees and bring down the scope of working hours working hours beyond the workplace. A person is made to work for 14 hours, and he is often made to check his emails or anything once he goes back home as well.
Article 21, please read it up. Article 21, can you read it up?
No person shall be deprived of his right to life. No person shall be deprived of his right to of his life or personal liberty except according to procedure established by law.
There are two issues here: deprivation of his life and personal liberty. Deprivation of life will not really come so it only goes into personal life, liberty. If your liberty is constrained and you're not able to move up because of work commitments, it will be only from that aspect of it. What material have you placed before the report with regard to this?
With regard to personal liberty?
Yes, personal liberty.
Again, a right to human dignity, right to decent environment, decent working conditions.
It is not handy. You can see exemption also. And you also have a duty to enforce your right, you need to speak up for it.
She did speak up for it. She,
What did you do?
it's clearly given in the proposition that she did contact her HR, producing her medical reports that she needs leave and reduction in her working hours has to go for her follow-up medical sessions. She was denied that. She was clearly, her emails were unheard. It is clearly stated in para 1.6 of the proposition. Therefore, it's clearly violation of right to personal liberty.
That report is not before the court.
It is there in the proposition, sir.
What is the statement?
It states, despite deteriorating health, she was unable to take a break. Her pleas to the team manager, HR department, to reduce her workload due to the onset of her medical conditions stated through email were unheard.
No, technically that would not be acceptable proposition because it would be hearsay. Somebody else is speaking on her behalf. She is no more there.
But according to the proposition,
Maybe according to the proposition, but for it acceptable really it would be primary statement. It is not a primary statement, it's somebody else speaking on her behalf.
but she clearly did,
Okay, the court will accept that statement.
because it is given in the facts of the case.
Right, you are wrong, it is there. But you have to convince us that it should be accepted as it is.
Yes, it has to be accepted because in order for her to redress her issues, she would firstly approach the HR manager itself, her manager. When she has approached that and it has gone unheard, she should have definitely approached the higher authorities. Approaching the higher authority may be a presumption, but here it is clearly stated that she did communicate about her medical condition to the. It is the fact. It is the fact stated.
Even as a fact stated, it is not substantiated in what I am trying to tell you.
It is substantiated in the following lines. The company stated that there is an increase.
What material you have?
We do not have any material for that.
Even if she passed away, the paperwork would be with her file. You would have had his commentary or you would have got clarification from the company itself as to whether this was exploitation, whether this happened. Have you taken those steps?
No, sir. We haven't. But we have relied with the facts that is given. And therefore, I would conclude my arguments by stating that this act is in clear violation of Article 14 and 21, and it is humbly submitted before the court that it should be declared ultra-virus because it is negative from the principles enshrined in Article 14 and 21 of the Constitution of... It lacks rational nexus. It does violate that object. It comes under. It is. While. But in the sub-arguments of Article 21, I did mention that it is clearly violative of right to human dignity, which it imposes a duty on the state to provide for decent environment for an individual. It is clearly in violation of that. It is a sub-argument under Article 21.
Yes.
My co-counsel would continue with the argument for issue 2. Thank you.
The council seeks permission to approach the dais. The council seeks permission to continue with the arguments of issue 2. Issue 2 is mainly focusing on whether the state has failed its constitutional duty under the Directive Principles of State Policy and various international frameworks such as ILO conventions, UDHR and ICESR. I would like to humbly submit before this Honorable Supreme Court of Indica that the Kandara Shops and Commercial Establishment Act is inconsistent and stands against the principles that is engraved in Part 4 of the Constitution. In Part 4, Article 39E mainly states that the health and strength of the workers should not be abused and the citizens cannot be forced only on based on economic necessity to enter into avocations which is unsuited to their age or health. I would like to state a case, CNF BV versus Union of India. The term burnout is defined. As my co-counsel has already defined the term burnout, it is something that causes danger to mental and physical health due to working overtime. Since the state has already legalized or normalized 14-hour workday policy, which constituted overtime previously before the amendment was passed, now the normal working hours itself is 14 hours, which is equal to overtime. Therefore, the employees will definitely be prone to bad physical and mental health conditions. And also in Article 41, it is stated that it is the state's duty to provide within its economic capacity and development to ensure right to work. However, if the employees are continuously exposed to overworking hours, they will be definitely prone to mental and physical health conditions such as burnout, fatigue, depression, hypertension, and can also lead something to as serious as heart diseases and heart problems. Therefore, the ability to perform well in the job role which is given to the employee will diminish, and some employees will also not be able to hold their employment. Therefore, which will directly deprive the right to work.
Also that hardly she died, but other materials are not, so that how will affect them?
So I have a
Government can take it into consideration that. Also, there may be working hours is 9. There is also they can work for an extra one, from that they will pay the salary. Taking the statistics, how many employees are working hours, what is their petition account? There may be increase 14 hours.
okay.
Do that. What is the material you have produced?
Yes, sir. I have the material.
There is no doubt. See, Article 21, right to life is a fundamental right. Yes, you establish that it is violated. We cannot be accepted that.
I have a report that is published in the ILO website by Science Direct Research Institute, which says long working hours will cause ischemic heart disease and stroke because of the long working hours. And it is
Describe that what is the working 5 hours is not long.
working hours in the sense working hours which are unreasonable. 9 hours working or 8 hours working is reasonable in many ILO conventions or our constitution. However, long working hours exceeds reasonable time. Therefore, in this report, where the council seeks permission to submit the evidence. Yes, sir. I can refer it. I have noted it down. It says that the report says that an estimated 7,45,194 death might happen because of exposure due to long working hours. It's an estimated death. They've considered all the fractions. They've considered people who are working for long working hours, and they've estimated. And also they've given the number of deaths in that report because of. Sir, the Science Direct Research Institute, through the ILO Convention official's website, has submitted this report. Okay, proceeding with the arguments. Speaking about Article 43, the Article 43 requires the state to endeavor to secure a decent standard of life, also providing for full enjoyment of rest and leisure and all other social and cultural opportunities. I would like to state the case D.F. Nakara versus Union of India, in which it says the basic framework of socialism is to provide decent standard of life especially for workers from cradle to grave, that is from birth to death. And in an important case, Crown Aluminium Works versus their workmen, it is stated that Article 43 discards the old doctrine of laissez-faire or the freedom of bargain between an individual employer and an individual worker, and it is directing the state to secure these rights of minimum wages and decent standard of life irrespective of the terms of the employment. And with reference to Article 42 and 43, we can understand the Constitution is having deep concern towards the health of the workers. And the courts may not actually enforce the directive principles of state policy, but the law should be enacted and the court should interpret law in such a way that the goals that are supposed to be achieved under the directive principles should not be hindered. And also the fundamental rights and the directive principles should work in harmony. And Article 51 states that the state should endeavor to promote just and honorable relations between other nations and also foster respect for international law and treaty obligations. In our case, Mubashir Javed
the states working hours.
no, sir, as such, no material as such. But in the case of Mubashir Javed Akbar versus Priya Ramani, Article 253 provides that the Parliament has the power to give effect to the international treaties and obligations. And also, in a case, Krishna and JP versus State of Andhra Pradesh, it is stated that Article 39 and Article 41 should be considered equally fundamental. By this, I would like to say that the state has failed its constitutional duty to keep in mind the directive principles of state policy before enacting such an amendment. Moving on to the ILO conventions, the Republic of India has been a signatory to ILO conventions since 1990. And to be specific, Hours of Work Industry Convention 1990 specifies the hours of work to be 8 hours a day and 48 hours a week, mainly 48 hours a week. And Occupational Safety and Health Convention of 1980. The amendment is 72 hours a week. Yes. It is 8 hours a day. Yeah, per day it has been, the cap limit has been raised to 40, per week it has been raised to 48 to 72. That's a drastic difference of the raise in the cap limit. That is what the council would like to state. And in the Occupational Safety and Health Convention 1981, the definition of health is defined. Health in relation to work is not only something which means absence of disease or infirmity, it also includes physical and mental elements affecting health which are directly related to safety and health working environment of the worker. And those are the conventions I would like to state under the International Labour Organization, and also the Ministry of Labour and Employment have formulated a policy called as National Policy on Safety and Health Environment at Workplace. The main object of this policy is to regulate all the management activities for all the economic activities for the management of health and safety of the workers. This policy really aims at ensuring the health and safety of the workers, aiming to prevent the accidents and injury that might arise to any employee in the course of his employment. And the aim is also to prevent and control or minimize the hazards that might be caused due to the work-related stress or pressure. Moving on to the international covenant.
And 24 hours consecutive pay, that means 1 day, working 6 days a week. 6 days a week is pay on an average. 5 hours with an hour break, 5 hours with an hour break.
Yes.
Technically, you are working 10 hours with a 2-hour break. It's not 14 hours, which the return 5 hours, break of 1 hour, and another 5 hours, break of 1 hour.
However,
And if you give the break break after 5 hours, they increase at the end of the day.
However, the break is essentially considered.
Only for 11 hours.
Right. The break is considered essentially to have their lunch, breakfast, or it might not be for any other purposes except for having their food, that is right to food under Article 21. However, these breaks also include in the working hours. The breaks that are provided by the establishment also constitute the working hours. The breaks that are not excluded. Therefore, together it is 14 hours. I would like to state that together it is 14 hours. The timings that children would say will probably be from 9:30 to 4 o'clock, it comes up to 7 to 8 hours.
Particularly, if the time, even if you're sitting and working, they are also sitting at the same time. They are also being
However, the school is different from a work establishment, Your Lordship. The school is a place to learn, and if the children don't engage themselves in learning, they might not have a very good future. However, in work, it includes a lot of pressure to meet deadlines, to go to the meetings, and all the other to fulfill all the duties that the manager is telling us to do. So when the person is under so much pressure, working for such long hours will also will add up to all of the pressure that the person is already having. And moving on to the International Covenant of Economic, Social and Cultural Rights, Article 5 of the Covenant clearly states that a state cannot perform any duty aiming at the destruction of freedom of any rights which are conferred under this covenant. And even if the limitations are imposed, it cannot be imposed greater than the extent that is allowed under this covenant. And I would like to state the case Maharaja College of Arts and Sciences versus the state of Tamil Nadu. In 1966, it says that it is a basic document, ICSR is a basic document which contains certain specific rights, but also includes certain work-related rights are also as human rights, such as the state of Kandana being a part of the Republic of India, however, is also obliged to follow these conventions. Just like the state of Tamil Nadu, the state of Andhra Pradesh, the state of Kandana also is obliged. That is how it is applicable to the state of Kandana.
So if you done it, then how can you self-create in that state? So the existing parameters in that state more and would be set by the need.
Indeed, Your Lordship. However, it is important that the state keeps in mind all the conventions to which the nation has been a signatory. Even though there are a few exceptions, or it is important that basic human rights is not violated. The state can enact laws, but keeping in mind that the human rights, which is very fundamental, is not violated. Moving ahead. Article 6 says that the right to work and every employee should have the right to safeguard this right. As I've already mentioned under Article 41, since the employee is prone to such bad mental and physical health conditions, he might not be able to safeguard this right completely. Article 7 says that safe and healthy working conditions, that comes under the ambit of just and favorable conditions, and also reasonable working hours and periodic holidays in time to time. Article 12 is a significant article under this covenant which says that right to enjoyment of highest attainable standards of physical and mental health. Highest attainable standard of physical and mental health, Your Lordship. However, through this amendment, the Council is concerned about even attaining the basic standard of health and physical and mental health. And also it aims at preventing, treating and controlling the endemic, epidemic and the occupational hazard that might arise due to the work-related activities. And moving on to the Occupational Safety Code 2020, in that code, section 18, subsection 2, clause A says that with regards to physical, chemical, biological hazards dealt with working life of an employee, no employee will suffer from material impairment on health and functional capacity, even if such employee has been it's been exposed to such hazards regularly. So it is violating this section also, because Rachel was though exposed to such hazardous working condition regularly, it was the state's duty to ensure that there was no material impairment which was caused to her. And in section 25, subsection 1, it says that no person will be allowed to work for more than 8 hours a day. But since the state has, through its, by the way of amendment, has normalized 14-hour workday policy, it is violating subsection 1 of section 25 too. Yes, sir.
Maybe when they are making a registration of the earlier, they thought of 9 hours because of change of service. And the whole developed countries, IT industries has been developed. They thought how it can be increased to 14 hours. Maybe this is all the reason state has taken a decision, because state has a responsibility to protect human rights as well as that economic growth also. In balancing that, state has implemented this.
Indeed, Your Lordship. However, the economies of the Republic of Indica or the state of Kandana is different from the other developed countries. Few of the developed countries, even though their economy is well developed and is booming, have still complied with the international obligations under various covenants or the conventions. However, the state, it has one of the biggest economies, and not complying with these international frameworks might restrict their access to international or global trade. It might also hamper the reputation under international activities or trade activities. And also, the state cannot assume things that, if the other countries are able to achieve it, our nation or the state also will be able to achieve it. It should consider all the local mindset of people, the health conditions, and all the other factors that might affect while making the amendment. And moving ahead with the Universal Declaration of Human Rights, Article 23, Article 24 and Article 25 talks about what are the rights, basic human rights that the nation has to provide to their citizens or any person of their nation. That is right to work, safe and healthy working conditions, right to rest and leisure, right to adequate standard of living and decent life. I've already stated how these rights are affected under various provisions of DPSP and International Covenant and ILO conventions. It is therefore violating the Universal Declaration of Human Rights, please, Your Lordship. The Council seeks permission to proceed with the prayer. It is humbly prayed to this Honorable Supreme Court of Republic of Indica, in the lights of the arguments advanced, issues raised and the authorities cited, this Honorable Court may please to declare the Kandana Shops and Commercial Establishments Amendment Act is violative of Article 14 and Article 21 of the Constitution of the Republic of Indica, and hold that the state has failed its constitutional duties constitutional duties under the directive principles of state policy and various international frameworks, including ILO conventions, ICESR, UDHR, and the Council requests the court to direct the state to fulfill its obligations under DPSP and pass any order, direction, or belief as it deems fit to uphold the principle of justice, equity, and conscience, and for this act of kindness, the petitioner shall forever humbly pray. Thank you.
The council seeks permission to approve. Much obliged. Your Lordships, the council is currently appearing for the on behalf of state of Kandana as part of respondents in this case of in-ray exploitation of IT sector workers. The council is speaker 1, my co-council is speaker 2, and I shall be dealing with issue 1, and my co-council will be dealing with issue 2. If the bench is already satisfied with the facts of the case, the council would like to move on with the arguments. Much obliged, Your Lordships. Your Lordships, the council has divided the arguments into 4 parts under issue 1, that there exists a reasonable classification to pass the test of Article 14. The issue 1, it is whether the Act violates Article 14 and 21 of the Constitution by legalizing excessive work hours that endanger employee health and well-being, Your Lordship. So the first limb of the argument is that there exists a reasonable classification. Secondly, that the number of 14 hours itself is not arbitrary. Furthermore, under Article 21. Indeed, Your Lordships. Your Lordships. Your Lordships, currently the cabinet has these reports per se. It is not before the court per se. In the next hearing, if the court permits, we shall submit it before you. We will come to that argument in detail in the next segment. Under Article 21, the council would like to submit that there is no violation of right of health of the workers of the IT sector, and that there is no violation of the personal liberty of the workers of the IT sector. Firstly, coming to the reasonable classification justification, I would like to bring the attention of your Lordships to the statement of objects and reasons of the Amendment Act of 2024, wherein under second limb, they have given economic and technological imperatives. Firstly, the information technology and business process management sectors are pivotal to Karnataka's economy, contributing significantly to employment and global competitiveness. Secondly, to align with international client demands across time zones and sustain Karnataka's position as a global IT hub, flexible work hours are essential. As such, under an amendment was brought into Section 7 of the Principal Act, stating that the Section 1A was inserted, wherein it was stated, employers in information technology and business process management establishments may work up to 14 hours daily and 72 hours weekly, subject to 1. Mandatory 1 hour rest intervals after every 5 hours of work, 2. Overtime wages at twice the normal rate under Section 8 for hours exceeding 9 daily and 48 weekly, and 1 day holiday has been given to the workers. So the state would like to bring to the notice of this court that it is a directory provision. It is wherein the companies have the option of implementing the act or not. Further, your Lordships, Your Lordships, before the amendment, I believe it was 50 hours with the overtime maximum. No, Your Lordships, 50 hours in a week. Your Lordships, under Section 7, daily and weekly hours. Subsection 1 provides no employee in any establishments, this is prior to the amendment. No employee in any establishment shall be required or allowed to work for more than 9 hours on any day and 48 hours in any weeks. The provisions provided that the total number of hours of work, including overtime, shall not exceed 10 hours in any day, except on days of stock taking and preparation of accounts. So 10 hours in a day was the maximum. Furthermore, Indeed, Your Lordship. Furthermore, Your Lordships, the current amendment does not provide for the same, which the... Indeed.
Now it's 14 hours, 4 hours has been increased.
Indeed, Your Lordship. Indeed. Your Lordships, for that purpose, the state government is pondering whether to bring in rules so that the power to exempt that the state government enjoys under Section 20 can be complied with, so that guidelines can be given to companies that you follow these guidelines, or else we will not give you permission to make your workers work for 14 hours. That is the current situation before the cabinet, because we have seen the tragic death of Rachel. Furthermore, Your Lordships, it is humbly submitted.
Something that because of the
No, Your Lordships. As the bench already rightly pointed out, the Amendment Act came into force on November 1, 2024, and prior to that itself, she had some health issues. And this may have aggravated her 14-hour daily work, or may have aggravated her condition. This might be one of the factors, but not the sole factor for her death. So, Your Lordships, I would like to bring... Indeed, Your Lordship. Indeed, Your Lordships. Indeed, Your Lordships.
Basically should be on the health issues. Are there any materials for the
Your Lordships, the data... Indeed, Your Lordships. For that purpose, actually, the state government has been given the power under Section 40 of the Principal Act to make rules with regard to health and safety of the workers. Power to make rules. One, the state government may by notification make rules to carry out the purposes of the Act. Two, in any particular and without prejudice to the generality of the foregoing power, rules made under subsection 1 may provide in respect of the health and safety and welfare of the employees. Currently, as the Amendment Act was enforced by the legislature itself by giving a date, November 1, 2024, the state government did not have adequate time to formulate the rules. The state government is currently formulating the rules so as to... Indeed.
Increasing that agreements itself is affecting that. Then you know, not that the purpose of making the rules will not serve.
See, rule delivery.
Indeed, Your Lordship.
See, going to be
11.
see context of that.
Section 11, insert 11A, special provisions for IT BPM establishments. A, employers must provide transportation and security for employees working beyond 8 p.m. B, health checkups every 6 months for employees working extended hours. So these are the limited safeguards provided by the legislature currently.
Providing the safeguard is secondary. First, if it is proved that if the employees work more than 9 hours, it will affect his health.
Your Lordships, currently...
Better to strike down the legislation or to allow you to do it, and after the employees suffered by any disease that you have to treat it, which is the better.
Your Lordships, the state does agree that the state...
If it is proved that
Indeed.
by enhancing that time rates, it will not affect the health of the employee in loss.
Indeed.
If some of them are 1 or 2%, it may be affected. Then you can go to the rules, they can be protected by giving it.
Indeed, Your Lordships.
Entire amendment which shows that it will affect large number of the employees.
Indeed. Your Lordships, the legislature is also contemplating whether to formulate a committee to examine whether health will be affected. It should have happened before. However, due to the urgency of the work, they could not do it. The legislature could not do it back then. Indeed, Your Lordship. It should have been done, that the council does agree. However,
After that, what is by the time so many aspects
no, Your Lordships, that is why under power to exempt, currently we are not granting any exemptions to any IT establishment so that they can enforce this Amendment Act. Currently the state government has stopped after Rachel's death. As such, we would like the legislature to act on it so that after getting the report from the committee, if they feel that the 14 hours is too much, they will amend the section back to whatever the committee recommends. Right now we are not, Your Lordship. After Rachel's death, the state government has stopped granting exemptions to IT sector companies. Furthermore, Your Lordships, I would like to bring to your attention the case of Transport and Dock Workers Union.
Have you seen the statement of objects and needs in writing number 4?
Indeed, Your Lordships.
What do you have to say about that?
Indeed, Your Lordships. Alignment with existing labor codes. The amendment harmonizes with Occupational Safety, Health and Working Conditions Code 2020. This code was brought in by the Union government. It has yet to be enforced as such. It has not been notified by the central government when it will be enforced. However, the provisions have been, the central code actually provides under section 25, I believe.
The notification indicates that it got to effect first of November 2024.
Your Lordships, the council is currently the Occupational Safety, Health and Working Conditions Code is not in force in the country of Indica, not yet. It has not been notified as such, according to the current news.
So, for each of these statements, made these statements of objects and reasons are accurate.
Your Lordships, the law has already been enacted. As such, in line with the law, we have drafted this amendment. However, whenever the central government notifies, that act may override this act. That again has to be determined by this honorable court. Your Lordships, moving ahead with my arguments, I would like to bring to your notice the case of Transport and Dock Workers Union versus Mumbai Port Trust, wherein Justice Markandeya Kardjo actually evolved a new test to pass the restrictions of Article 14, wherein I would like to submit a copy of the parts of the judgment that are relevant, wherein under page number 576 continued to 577, it was held, the main issue in this appeal was whether the action of Respondent 1 in the prescribing longer working hours for typist cum computer clerks working in their indoor establishment with reference to their date of appointment was contrary to the guarantee contained in Article 14 of the Constitution, Part G. So, dismissing the appeal, the Supreme Court held Article 14 of the Constitution is a slippery slope and the fine balancing act must be done by the court to avoid slipping down the slope. Article 14 cannot be interpreted in a doctrinaire or dogmatic manner. Absolute and inflexible concepts are an anathema to progress and change. Furthermore, Part E says the classification in question is reasonable because it satisfies. Indeed, Your Lordships. Indeed. Publisher. Indeed. Indeed, Your Lordships. However, due to financial constraints, as students, we could not. Indeed, Your Lordships. For state, however, the Moot court rules do not mandate as such. Apologies, Your Lordship. So, in the classification in question is reasonable because it satisfied the test of social conduciveness. As per this test, is that if a classification is conducive to the functioning of modern society, then it certainly is reasonable and rational. The functioning of modern society, I would argue, Your Lordship, that currently everything is based on software. India is becoming digitized, even for money transaction or anything. Even if you want government services, everything is digitized now. As such, IT sector has become the backbone of the country. As such, we need more working hours for a limited period of time so that the sector can be strengthened. Your Lordships, indeed, Your Lordship. Your Lordships, however, it is a specialized kind of work. If a person starts working on something and he leaves, every person in the IT sector has a different way of working. So it cannot just be handed over like how it is done in a mechanical factory where a process has to be followed. Some persons like Rachel, she had specialized knowledge. As such, we have just increased the working hours. That too, only to such specialized persons, the companies would rationally apply it.
However, for the experts, you can't
make them. Indeed. Indeed, Your Lordships. However, a rational company would only apply it to experts and pay them extremely well. However, the current companies, as we have seen, are exploitative, and we would like to take action under Section 30 of the Amendment Act. Section 6 of the Amendment Act says amendment of Section 30. In Section 30 of the Principal Act, insert a new subsection 4. Contravention of provisions under Section 1A or 11A shall be punishable with A. First offence, fine up to rupees 50,000. B. Subsequent offences, imprisonment up to 3 months and or fine up to 1 lakh. So, Section 30 is in the Principal Act. Indeed, penalties, Your Lordship. So, it provides for penalties, and extra penalties have been added to the section. So, the state would like to sit on an inquiry against the company, ANZ company, so that the real cause of Rachel's death could be found out. And if the company is found in contravention of the act, as the proposition states that she was made to work 15 or 16 hours continuously, Your Lordships, I would like to request for some more time. Indeed, Your Lordships. If the company is found in contravention of the Amendment Act, the state shall rightly penalize the company. Furthermore, the legislature may also, after the committee reports back to it, may increase the amount of penalty, because these are huge multinational companies and 50,000 and 1 lakh rupees may not be sufficient. Furthermore, Your Lordships, coming to social conduciveness, the council has already argued. Coming to the point of Amendment Act is not arbitrary. It is a policy decision that the legislature has taken.
For the economy or the pressure of that employee,
Your Lordships, currently it is already well known that IT sector, Bangalore IT sector is infamous for its worse working hours to IT sector employees, and as such the government has tried to maintain the status quo. When even before this amendment, they were made to work for 12 to 14 hours, as witnessed by the case of Rachel. As such, the government has just brought in the amendment so that their work can be rationalized and they can be paid. The government is intending that in the future, currently if the government reduces the working hours strictly and applies it, the IT sector will move away from Bangalore. As is, in the future, gradually we will reduce the working hours of IT sector so that workers can be benefited. Here, what was happening underground has been rationalized. As such, the council would like to move on to the arbitrary argument. It is a policy decision. As such, the status quo has been maintained by the legislature, and furthermore, it is argued that the materials before the cabinet will be placed before this honorable court in the next hearing, so that this court can get more clarity. And furthermore, when passing the Amendment Act, it has gone through both the houses of Kandana's legislative body, wherein Kandana has a unique legislature wherein two... Indeed. So, two houses have scrutinized the amendment and have passed it. As such, indeed, validity can be challenged. However, if the court finds that the Amendment Act is violative, I would ask the court to give functionality to the law rather than to strike it down as unconstitutional, as it is one of the principal rules of interpretation that better to give functionality to the law rather than to strike it down as unconstitutional. Coming to right of health of workers, Your Lordships, there are sufficient safeguards, as the bench rightly mentioned. The 14-hour work day consists of 2 hours of rest. So maximum they are working for 12 hours. And even unskilled laborers at times with sufficient rest are allowed to work for 12 hours in a day. Even doctors and even attorneys ourselves and even judges for that matter sit for 12 hours in a day. So it is not unreasonable per se, the 14-hour work week, because there is mandatory rest happening, which the company did not provide to Rachel. As such, it may have aggravated and led to her death. So again, the state is ready to sit in inquiry about it. Furthermore, with regard to personal liberty, Your Lordships, the Amendment Act is not penal in nature. It provides for extra compensation to the persons who are working more than 9 hours in a day or 48 hours in a week at twice the rate, so that they are rightly compensated. This cannot be considered as... Indeed, Your Lordship. Indeed, Your Lordship. Currently, there are no such safeguards, Your Lordships. Indeed, Your Lordships, currently this safeguard does not exist, but the bench's advice is duly noted, and it will be placed before the cabinet that while making the rules, leave it to the employee rather than the employer to choose whether to work for 14 hours or not. If you let the employer do it, they will mandatorily make you work for 14 hours without any regard to your health, as we have seen in the case of Rachel. So better to let the employee choose whether to work for 14 hours because the monetary compensation is huge or not. So the state government will contemplate on that as well. The bench's suggestion is duly noted. With regard to personal liberty of workers, Your Lordships, as the bench already calculated, 72 hours of work in a day, work in a week would amount to, if you continuously work for 14 hours daily, it would amount to 5 days in a week. So the legislature has contemplated that 2 days would be off, and mandatorily it has said 1 day would be off. As such, personal liberty of the employees is not violated. As 2 days off, they can socially mingle, they can have a check on their mental health. And with regard to mental health, the government of Indica has also come up with many policies which my co-counsel will be dealing with it. Furthermore, in the state of Gujarat versus Honorable High Court of Gujarat, where the High Court had to define what is the system of begaring, the question was with regard to prisoners getting wages, wherein one of the judges dissented, saying that prisoners don't need wages, it would not amount to forced labor. However, wages were provided to prisoners by the majority of the court, saying that without wages it would amount to forced labor. Here, as I have already pointed out, the Amendment Act provides for more wages rather than less wages. The council would like to rest its arguments here. My co-counsel will be dealing with the second issue. It was a pleasure arguing before this bench. Much obliged.
Council seeks permission to oppose this. Much obliged. The council seeks permission to address this honorable bench as Your Lordship. Much obliged. Your Lordship, I will be dealing with the issue 2 that talks about whether the state of Kannada failed its constitutional duty to ensure the safety and health of the worker, and that in furtherance violate the DPSP and international law. Your Lordship, Indica is a sovereign, secular, socialist, democratic and republic country. Here the word socialist and sovereign, from which I will substantiate how international norm and how state of Kannada and Republic of Indica has fostered the socialist principle. Your Lordship, in the case of state of Andhra Pradesh versus McDowell, this honorable court has already stated that to determine the constitutionality of any statute, 2 things is primary. One, first is whether the legislature has the competency, and second, whether it is violative of fundamental right. If the statute is constitutional in nature, then basic structure doctrine can also become. Your Lordship, the state of Kannada has the legislative competency under List 3 and entry 24 and 25. Your Lordship, the impugned act, the act is not violative of any part of Part 3 and Part 4. The state of Kannada and Republic of India. No, indeed, no, Your Lordship. It is not. I will substantiate. No, Your Lordship. Your Lordship, Article 21 is very wide article. It is a heart of Constitution, and state of Kannada and Republic of Indica has already taken much more step to foster the security, safety and health of the people.
Taking any clear person after you can avoid this suffering. If that would be the case, then you were also on the road that they may suffer by using that 4 hours.
Indeed, Your Lordship. However, the petitioner didn't justify the sufficient ground how it is.
Any other state they have made any amendment?
No, Your Lordship. Your Lordship, the whole act and the amendment, it's primarily temporary in nature. Your Lordship, Indica, and in Indica, 50% plus GDP is come from tertiary sector, and this tertiary sector is nothing but the IT people and the processing-based workers who works and who contribute in the GDP. Your Lordship, when in 1979, WHO first time talks about mental health in very expressly way. Indica was the one of the first country that launched National Mental Health Program in 1982. In furtherance, Your Lordship, State of Kannada and Republic of India has taken much more step. In 1996, a district mental health program has been introduced that also talks about mental health. Your Lordship, in our country, there are more than 790 districts, and this district mental health program is functional more than 738 district. Your Lordship, in furtherance, in 2014, we come with mental health policy. Later, after the success of that mental health policy, we enacted Mental Health Act of 2017. That also talk and covers the mental health at workplace or any person who is by birth lunatic or having any kind of sufferings. Your Lordship, in 2018, we established and we enacted Rights of Person with Disability Act of 2016. That also covers the same thing. Your Lordship, during the time of COVID, it was not
Exemption for disabilities person?
regarding
Working hours.
indeed, Your Lordship. Your Lordship, based on their competency, the Act works. As my co-counsel said, Article 40, Section 40 of the Shops and Commercial Establishment Act talks about the rule. The Cabinet is in process of... Your Lordship, it only talks about the health and how health should be given to people. In furtherance, in the time of COVID, we launched Kiran Helpline. The toll-free number was 1-800-599-0019. That was specifically fostering and focused for the people who work from home, because that was not a easy time for us. The world has never seen such a pandemic. Your Lordship, one of the most vital program what government has introduced, it is National Tele-Mental Health Program, that is Telemanas, through which 24/7 policy and 24/7 mental health support has been covered to any people. It also expands to people who works in workplace. Your Lordship, furthermore, when this on 10th October 2022, this Telemanas program has been introduced. Till now, 7th Feb 2025, till now 1.8781 million people has been benefited from this Telemanas Yojana. It is 24/7 program through which any person can take benefit. Even WHO has recommended.
Even for working 9 hours also, they are suffering this. Still wants to enhance to 14 hours.
Your Lordship, the mental health, it is not only limited to India. It is a global, in this global era, it is a problem for all. And all the countries should come together on the municipal and domestic level and in the international level too. Indeed not. No, Your Lordship. The 14-hour work thing, it is not continuous 14-hour.
There is statistics that by enhancing that 14 hours, what is the economy will what the percentage?
Your Lordship, even for 9 hours too, there is no such statistic that shows that only 9-hour work is benefited. When in 1919, the ILO gave the 8-hour works, that was the time of police state. The life expectancy was 38 years. A person was not able to live more than 38 or 39. Right now, in our country, the expectancy is 78. We are fostering the advanced level healthcare and other things. And this 14-hour doesn't continue for 14 hours. In between, they have break. And the IT worker doesn't need to work in physical place. They can do work from home. Virtually, they can continue their work. So, they have this chance of doing their work at home. They have chance of working 2 hours, then they can spend some time with their family. Again, 2 hours. It doesn't talk about compulsorily they have to work for 14 hours. So, it is just an enablement that is fostering the economy, the growth, the health, and all other perspective of Republic of India. Because right now, last year only our Prime Minister gave this theory of Viksit Bharat. In 2047 we have to be Viksit Bharat. So for this is an enablement provision. Furthermore, Your Lordship, In 2017, the government stated that by 2025, we will spend 2.5% of our GDP to healthcare. I have this report, but last year only they spent 3.8% of their GDP. So in 2017, they only thought of 2.5%, but right now we are in 2025, but now it is 3.8. So we are fostering our DPSP, international norm, and all other protocols we are following. International norms we should adhere as a country as stipulated in Article 51C. However, Article 253 gives the protection that until Parliament pass those international norm, till then that norm would not be a binding, it's just a persuasive value. Indica and State of Kannada has taken all the prerequisite what should be there and how we can tackle this mental health problem. Your Lordship, furthermore, Your Lordship, this Telemanas Yojana, what I mentioned, it introduced in 2022. Right now, it has been integrated with Pradhan Mantri Arogya Yojana. So all the data of a person, if he is tackling with any kind of mental disorder or mental disability, that can be covered. That government will know, and through this Telemanas Yojana, the Tier 2 system talks about how if I call the authority that I am suffering from mental disorder, one of the official and one of the doctor can come to my place, my home, or either I can directly go to hospital. Your Lordship, para number 44 of the petitioners, Respondent's memorial, since 2014, the UG and PG seats for health has been increased by 112% and 127% respectively. So we are fostering and we are checking what can be done in the best possible way. Your Lordship, again in para 44, centrally sponsored scheme talks about how from 2014 we have established 157 new colleges, and these medical colleges also talks about mental health, and in India right now we have specialized colleges and centers for mental health. Your Lordship, we have 25 center of excellence specifically for mental health. We
Let us take more care about the hospital itself. Have you taken any care that
Indeed, Your Lordship. Your Lordship. Your Lordship, there is a program that called Employee Assessment Program that has been launched. It was inspired by the function and the diagram of that happened in UK, and right now many public sector units in India follow that, and one of the unit is one of the unit is Insurance Regulatory and Development Authority of India. This talks about personalized mental care help. If in a workplace, if an employee is suffering from any kind of ADHD or any kind of mental disorder, they can go to this mental care center, that is Employee Assessment Program, and they can get relief. Your Lordship, furthermore,
I just want to point out to you that the Amending Act, in its statement of objects and reasons, has indicated the sort of special status to information technology and business process management.
Your Lordship.
One of the special issue over here is to align with international brand demands across time zones and sustain Karnataka's position in what they put here as a global IT hub. Flexible working hours are essential.
Indeed, Your Lordship. Indeed, Your Lordship.
Factors also that come into play here.
Indeed, Your Lordship.
The legislator has really made a mistake by enacting this particular amendment.
No, Your Lordship, it's just an enablement, and
You should explain that to us. How you should sustain the rationale for the introduction of this amendment.
Your Lordship, Indica being a developing country, and we are right now in the name of purchasing power parity, third largest economy. To align with the international standard, we should change our existing legislation so that those legislations. Indeed, Lordship, that is why. Indeed, Lordship, that is why we have providing flexible work hour. So a person can, if in America the time is 12 o'clock in the afternoon, and in India it is 6 o'clock, then the worker can do their work at midnight. They can do their work anytime. Indeed, Your Lordship, the IT sector is a specialized sector where physical presence is not required. Virtually they can work. So from work from home also, they can align with the time zones, and each person will get one time zone. So if a person is getting a time zone according to China, he has to just adhere to the time zone what's happening.
The only question I would place before you is, do you think the Amendment Act has provided here meets these requirements for the rational in favor of objective reason?
Indeed, Lordship, as my co-counsel has already stated that in the state of Kamana, the working hour practice was not good. So to align and to give the border what should be the upper threshold after which if a person is working, that should be unconstitutional and that should be illegal. So that this amendment has been come, and it is aligned with international norm and DPSP. Furthermore, Your Lordship, and this court has been, the state already has been secured and presumed the role of parent patry. Parent patry is nothing but to safeguard the rights and liberty of the people. Your Lordship, Article 21 talks about right to health under right to life. However, this right to health is not equivalent to right to healthy. So state is giving in its best possible way what should be done. State is providing much more health care, much more assistance regarding mental health and other things. However, this right to be healthy, it is a subjective thing. So if a person is suffering from a mental disorder or any kind of mental illness, state can provide assistance, but that doesn't mean that the person will be cured. It is the subjective thing. Your Lordship, furthermore, Your Lordship, I seek few more minutes. Much obliged, Your Lordship. Your Lordship, in the, to get the final judgment of, to come to the conclusion in the case of Keshav and Bhati versus State of Kerala, all the majority, Your Lordship and Justice, gave much more importance to preamble and the DPSP. Your Lordship, DPSP are fundamentals, and it should be complementary and supplementary to fundamental right. And State of Kamana has fostered it and adhered to the same thing. Your Lordship, furthermore, the ILO Convention 155 that has been referred in the in para number 67 and 187 talks about the working hour and the work condition. Your Lordship, in 2022, the same convention has been made fundamental. Indica being the founding member of ILO in 1919, and we are the forerunner of labor law. In our country, we have a specialized ministry for labor too. So the whole act and the whole action of government was the organic step. It was not a mechanical step where we just pass a law. We took consideration of all the stakeholders. The bill passed with proper majority in both the houses, and we are in consonance with the DPSP and International Convention. Your Lordship, in furtherance, para 79 talks about how Article 253 talks about giving effect to international treaty, protocol, convention, and many other things. However, a treaty entered into by India cannot become law of a land, and it cannot be implemented unless Parliament passes a law that required under 253. That has been referred further in furtherance in the case of Jolly George, Varghese and others versus Bank of Kochi, citation number 1980 to SEC 360. The court has said the positive commitment of the state parties ignite legislation action at home, but does not automatically make the covenant as enforceable part of the corpus juris of India. Your Lordship, it has persuasive value. The demography, the structure and the another thing of Indica is different what is in Europe and other country. We are adhering the international norm by securing the quality of life and the economic growth. Your Lordship, with this, I will conclude with prayer. In light of facts stated, issue raised, argument advanced and authority cited, it is most humbly and respectfully prayed before this Honorable Supreme Court that it may be pleased to hold and declare that Common Shop and Commercial Establishment Act 2024 is constitutional on the ground of no violation of fundamental right. Hold and declare that the state of Common has fulfilled its constitutional duty to secure workers' health and safety and discharge its obligation under DPSP of the Indian Constitution and various other international framework, and pass any order that this honorable bench may deem fit in the proper deem fit and proper and of justice, equity and good conscience. Much obliged.
Council 6 permission to approach the time. The Council seeks permission to proceed with the rebuttal. During the arguments of the respondents, they stated that the cap limit that is specified in the Amendment Act is 50 hours per month. But however, it is 50 hours for 3 months. It is clear in the Kannada Shops and Commercial Establishment Act. The cap limit for overtime working hours is 50 hours for 3 months, not 1 month. In the Kannada Shops and Commercial Establishment Act. I will provide you with the provision. Can I move ahead? The opponent counsel also mentioned that one of the reasons for Rachel's death is the work-related stress. It does not mean the state is accepting that Rachel's death might be caused because of one of the is caused because of work-related stress. Are they considering that reason also by themselves? And also, the opponent has stated that the state government will have stopped after Rachel's death, stopped granting exemptions. They failed to provide what are the measures that the state has taken to stop. However, the Amendment Act clearly says that this increasing the 14-hour workday cap limit is for IT and the business process management.
They have effort done to implementing the
The council doesn't understand how they deferred the act, and they've not shown anything that the. There is no such notification that insists that the Amendment Act has been deferred. They have considered while enacting the legislation that since the proposal was from the IT industry.
Your Lordship, Your Lordships, in the next hearing, we will provide the notification provided by the state government. Indeed, Your Lordship. If you read the plain meaning of power to exempt under Section 20, the state government may exempt IT or BPM establishment from Section 7.1, which is 48 hours and 9 weeks, 9 hours, and 12(1) if they comply with section 7(1)(a) and 11(a). There was a clear violation of 7(1)(a) and 11(a. As such, we have deferred the implementation of the act. Indeed. Indeed, Your Lordship. However, exemptions are not being granted. Indirectly, we are not implementing, Your Lordship. Indeed, it is enforced because the act has come into force because it has been appointed by the legislature itself. It shall come into force on 1st November 2024. Notification need not have been provided by the state government, but we have again provided, just to reiterate the point that the legislature has. However, indirectly, the state government can stop the implementation of the act through exemption. It is in force currently. However, we are not granting exemptions to any IT company so that they can enforce it.
Well, I would like to ask, where is the notification? Why is it not made publicly available for all the people? Continuing with the rebuttal. Since the proposal for the amendment increasing the working hours is proposed by the IT industry, they have considered the proposal of only the employers and employer's perspective, and the state has not provided any report as to consideration of the employee's perspective. And they also stated that sitting for 12 hours or 14 hours is not unreasonable. According to the appellate counsel, what is the reasonable timings to continuously work? If 14 hours or 12 hours is unreasonable, I am concerned that the state is giving more hours as reasonable. And they also contended that 72 hours gives 2 days off. Then why did they increase the cap limit of per day to 14 hours? And they also stated that the Republic of India is a sovereign nation. The sovereignty of a nation gives power to violate the fundamental rights of its citizens. The state, despite knowing the consequences of work-related... Why is the state very ambiguous about it?
14 hours. Practically 72 hours is the week. It can be distributed in 7 days in or 5 days a week.
However, the previous provision says that 9 hours per day is the cap limit, and with that being said, itself the workers have faced a lot of stress and health issues. Now the state has given provisions to increase it to 14 hours, then the establishment will not even think twice to exploit their workers, since there is an already enacted law which is giving them power to do so. And how does the opponent counsel prove that the act is temporary in nature? And they also mentioned that the life expectancy of the nation has increased. And by increasing cap limit, does it mean that the state can make laws that will affect the life of the citizens or employees, that can reduce the life expectancy, again go back to fall into something very worse? And all the other social cultural rights are also affected. In a day consisting of 24 hours, if a person is working for 14 hours normally without overtime, then where does he have the right to exercise all these other social rights, mingle with his family, make friends, or do anything else if he is continuously working? And what is the point of coming up with schemes while the state is simultaneously enacting amendments to deteriorate the health of the very citizens of their nations? And when the upper threshold was 9 hours, the employees were clearly exploited. Now, why is the state increasing such the threshold limit despite knowing that the employees are still going to get exploited? And there is no report submitted that the state has also considered employees' perspective in enacting the laws. Therefore, I would like to conclude with my rebuttals.
The council seeks permission to approve stay.
No, you have no.
Sir, rebuttals are allowed according to the.
No.
Indeed, Your Lordship. The council rests.
Yes, that's all.
Thank you, Petitioner, and the Respondent. The Petitioner and the Honorable Bench, the time and patience shown by the bench is duly and sincerely appreciated. The Honorable Bench is pleased to proceed for the conjunction. Thank you all.
That's